Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates and licensed immigration attorneys come together to understand US policies and procedures better. My name is GB Satusa and I'll be a host for today's important discussion. What to expect during consular processing for family-based immigrant visas. Now, many families pursuing immigration to the United States will have to undergo consular processing as a vital step in obtaining an immigrant visa. The process involves multiple stages, documentation requirements, and an in-person interview at a US consulate or embassy abroad. Now, understanding how the process works, what challenges may arise, and how to properly prepare can help applicants avoid mistakes and approach their case with greater confidence. To help us break this down, we are honored to be joined by Tiffney Johnson, Esquire, an experienced immigration attorney who guides families through consular processing and helps applicants navigate interviews, documentation, and post-interview procedures. Attorney Johnson, thank you so much for joining us today. We're always thrilled to have you for these important discussions.
Thank you so much.
Before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding consular processing for family-based immigrant visas. Attorney Johnson, let's dive right in. To begin, can you state the steps in the consular processing journey for a family-based immigrant visa?
Sure. So after USCIS approves your case, it is sent to the National Visa Center. And if a visa is available in your category, very shortly you'll receive an email from the National Visa Center with instructions to pay your fees, fill out the DS-260, which is an online visa application for immigrant visas, and instructions on how to upload all the required documents for your case. This will include all your civil documents like birth certificates, marriage certificates, that kind of thing, police certificates, and the entire affidavit of support packet that you have to fill out to show that your petitioner can financially support you. When all these steps are complete, then your case is considered documentarily qualified. And so that is what determines your place in the queue to be interviewed. And once your interview is scheduled, which is basically a first come, first serve, after your document qualified based on the wait time at a particular embassy or consulate. So once it's scheduled, then you'll get a whole new set of instructions that are specific to that location. And at this stage, then you will obtain your medical exam, update any kind of outdated or expired documents. Right. And then at your interview, you'll provide all your original documents. Okay. After the interview, if everything's in order, within about a week or so, you'll receive your immigrant visa, which will serve as your temporary green card when you enter the United States.
All right. Now, what are the biggest challenges applicants facing in consular processing today, specifically in 2026?
Yeah, well, of course, there's the pause, which has affected a lot of people in a lot of places. Yeah. And although those are still being interviewed, the visas are not being issued. There's also new AI tools that are being used to detect past visa misuse and fraud. and identify other areas of concern in a case. So applicants are sometimes now being asked for things they were not asked for in the past to in response to some of the what officers are seeing by using these tools. Additionally, the enhanced public charge standards are in effect, although right now they are not codified and are still quite subjective. The enhanced standard, it's still subjective, and they're not being applied very uniformly around the world. So depending on where you are, you may be asked for different things and based to show that you're not going to be a public charge depending on benefits when you come to the United States.
All right.
And I will say, public charge, though, the entire affidavit of support has always been the number one reason that an immigrant visa case gets delayed, put on hold, because it is a financial document and it has to meet very strict standards.
Yeah. Now, how important is the applicant's location or assigned consulate in determining how quickly a case moves forward?
Well, luckily today, there is a tool online you can look at called the IV Scheduling Status Tool, and that will tell you the wait time based on your category at a particular place, okay? I just looked online last night to kind of compare some of the more common places, and one of the longer wait times, of course, is Ciudad Juarez. That is about a year, and up to a place like Sydney, Australia, where the wait time is only about a month. And then there's a lot of places in between at the 4, 5, 6 month wait time. So it does make some difference, but it's not huge, but it does make some difference.
Yeah. Now, what types of questions are commonly asked in family-based cases, and how can applicants prepare this effectively?
Well, some of the questions in family-based are the same as you'll see across all categories, related to your travel history to the United States, your immigration history, your criminal history, and other security-related concerns, reviewing your medical exam results. Those are all pretty uniform across all categories. In family-based categories, you will see a lot of questions focused on the relationship, the marital relationship, and that's whether you're the petitioner for a spouse or whether you're, let's say it's your brother or sister petitioning for you, then those questions may be about you and your dependent spouse. So either way, the marital relationship questions will be there. And if in other categories, there may be questions to try to verify the biological connection between the two applicants, if that's between the applicant and the petitioner, if that's relevant, or the applicant and their dependents. And of course, there also are going to be public charge questions related to how you're going to support yourself, but also related to the petitioner sometimes and what they do in their employment. The most important way to prepare for these questions is to know what is in your application. So you should have the entire packet of everything that was submitted for your case from the first step of the petition through the NVC process. You should know what is on that DS-260. You really need to know that information and know what the officer is looking at, just so you can be prepared and answer their questions in an educated way. Yeah. So if you're trying to prepare for questions about your relationship, just before your interview, try to remember these important milestones of your relationship. You don't need to know exact dates, but when you met and how you met and when you first met each other in person. Sometimes that's, these day and age, a lot of people meet online. That all those kinds of important things in your relationship. Just refresh your memory, because maybe it's been a long time since some of those things happened. And you should feel comfortable that as long as you're in a real relationship, you'll be fine. You'll know the answers to those questions. And you should also try to anticipate any public charge concerns if you think that is an area of your case that may be weak, so you can address them in an informed manner.
All right. Now, how has increased screening and vetting changed the interview experience in recent years?
Well, it has more so changed really the types of evidence that is being requested for applicants. Officers are empowered to ask for any kind of evidence to make their final determination. And some of this is not going to be evidence you may have anticipated or that may be standard for an immigrant visa case. The enhanced public charge standards also are leading to many more questions about things like health insurance, your plans for self-support, and expectations that you know what it costs to live in the United States, especially if the petitioner is not your spouse or if they don't qualify as a financial sponsor and you're using a joint sponsor.
All right. Now, what is administrative processing and why are some cases placed into it after the interview?
Okay, well, there are administrative processing is a very broad term that is basically means that your case is being put on hold for a particular reason. Okay, some reason. There's different reasons though why cases go into administrative processing. Some things may be relatively quick and some may take a long time. So some of the administrative processing is security related and it is mandatory and there's nothing you can do about it except if you want to bring your CV and list of publications to your interview, that may speed things up because it's a common thing that is asked for with this type of administrative processing. Okay, so if that's something that is if you're a person with education and that kind of thing, you should bring that and it won't hurt. It could speed up your case if your case is sent to administrative processing. The paused cases are now being put in. Most people are being told it's in administrative processing, and all that means is the case is just sitting there. Then you may have been asked for other documentation related to public charge because if you're from a paused country, but usually it just meaning we're not issuing your visa yet because we can't do it. Administrative processing can sometimes mean the officer just needs to do additional research to make sure you qualify. This is really relevant if people have spent a lot of time in the United States previously. Maybe you were a student and then you changed your status to this and then you changed your status to that and now you're consular processing. So they want to verify that you didn't have any lapses in a status that may make you ineligible. Nowadays, you also have a lot of people that have applied for asylum, cannot consular process a case for whatever reason, and now they are can't adjust status. They need to consular process. So consular officers are wanting to make sure they complied with the terms of their of asylum, no unauthorized work, and that kind of thing. The way you can really help with those kinds of things is if you've been in the United States and had a lot of changes of status and that kind of thing, take all your I-797s, which are the receipts you get from immigration, with you, because it makes it a lot easier for the consular officer if they have that. And then they can go and just verify it rather than them having to research it themselves. In fact, they will usually ask you for it before they even start looking at anything. If you happen to have a criminal conviction, take your court records with you. It will delay your case. If the officer may be able to review them right then and there and determine you don't have an ineligibility. But if you don't bring them and provide them full court records, sometimes they just don't have enough information to make that determination. Also, there is, we're seeing, with students, their cases are all being put in administrative processing for this enhanced social media vetting. And you may start seeing that also with green cards. So I would not be surprised if that is in the pipeline for immigrant visas as well.
All right. Now, Attorney, when should applicants seek legal help during the consular processing?
Well, if you're working with a lawyer from the beginning of your case, I would highly recommend continuing that relationship until you receive your immigrant visa. An attorney can accurately prepare the affidavit of support, which I mentioned is the number one reason that immigrant visas cases get delayed or they're denied under this code 221G, which means basically you didn't provide the documents you needed to provide at the time of the interview. And an attorney can help you also identify any other challenges you might have and help you prepare for them so there's not delays in your case. And if you have one very important category of people that should use an attorney for their consular processing is if you have an I-601A waiver because you were unlawfully present in the United States and you're leaving the US just for your consular processing, it is really important that you have someone reviewing your case to make sure there are no other ineligibilities, even for public charge. So if your case is not approvable, if it's at that time, your I-601A waiver and all that time you waited will be for nothing because it will be invalidated and you will have to apply for an entirely new waiver. And that is a really sad situation. So that is a situation where it's really important to continue working with your attorney throughout the process.
Now, are there any situations where applicants should consider alternative strategies, such as adjustment of status?
Sure. So adjustment of status often will make sense. For example, if someone has overstayed their visa and they are the beneficiary of an immediate relative petition, because in that case, if they leave the United States, they could be subject to a bar and not able to consular process without a waiver. So those are cases where it may make sense for adjustment of status. Also, people who are in the US on dual intent types of visas like H-1Bs and L-1s. Those are two categories of visa where you can have an adjustment of status pending and you are still free to travel on your H-1B and L-1 back and forth, and it doesn't affect your adjustment of status application. But adjustment of status versus consular processing is actually a very strategic and case-specific decision. And you really need to work with an attorney to decide which is the right thing for you. And above all, do not come to the US on a non-dual intent visa with an expectation to adjust status. This can have all kinds of permanent consequences. And even if you have a pending or approved petition and you plan to consular process and you just want to visit the United States, you should still talk to your attorney first to evaluate the risks of traveling to the US while this process is ongoing.
Okay, all right. Thank you so much for those insights, attorney.
Thank you.
Now, for everyone watching, this discussion about consular processing is not meant to create any anxiety, but to provide clarity about what applicants may experience throughout the process. Careful preparation, understanding timelines, and staying informed can help families navigate this journey more effectively. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified. This just shows our commitment to transparency, community education, accountability, and security. Attorney Johnson, based on your experience assisting families through consular processing, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Well, there is a lot of information out there for people who are going through the immigration process. Some of it is good, some of it is not accurate. And with family-based immigration, you're also very likely to have a lot of people who've gone through the process who have their own opinions, you know, in your family and your friends have their own opinions about what you should do in the process. So it is really important that you know where you're getting your information from, that is a good source of information. And ImmigrationQuestion.com has attorneys on their platform who are vetting the information that is provided. So that is the type of source of information where you want to be going when you're trying to make these decisions about your case.
Thank you so much, attorney. Now, before we go into our live Q&A, let's tackle this important question. What is a common misconception that applicants have about consular processing that you believe should be clarified before embarking on the process?
Well, some applicants, especially ones who have gone for tourist visas and things like that, other types of visas before, maybe they were denied and they don't know why. An immigrant visa interview and process is nothing like that. It is not a subjective process. If you qualify for the visa, the officer is obligated to issue it. So this is not an evaluation of a lot of other sort of nebulous criteria that you may not understand. This is a very, black and white type of evaluation. And other than sort of the evaluation of the marital relationship, and nowadays a little bit of public charge, it is really a yes or no decision for the officer. So if you are prepared for the interview with, your documents are prepared for the interview, and you meet those qualifications with the relationship, your visa is going to be issued. And another sort of good benefit of consular processing that a lot of people don't really think about is that when you enter with that immigrant visa, you are immediately able to start work. You can even travel, all those things. And with the adjustment of status process, you're going to spend a lot of time in an uncertain status where you may not be able to travel at all, and it could take you, and you can't work for some of that time. So really, everyone should make, like I said, this is a strategic decision, and there are a lot of factors that point a lot of people towards consular processing once they understand what it means.
All right. If you've just joined us, we've been speaking with attorney Tiffney Johnson on what to expect during consular processing for family-based immigrant visas. We're now moving into our live Q&A session. This is your opportunity to ask general information and hear educational insight from a licensed immigration attorney. So please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. Right. AOFI is asking, all my documents are complete, but no interview yet. Please, is this normal?
Yes, it's very, very normal. As I mentioned before, the IV scheduling status tool, you can Google those words exactly. It should be the first thing that pops up, and you can select your type of case. Be careful if selecting immediate relative means, spouse or minor child. Family based, I believe they call it, means your spouse is you're on a category that has usually a green card petitioner or one of the other, they call them preference categories, where they're numerically limited. So you can check that, and you can see if your case is normal. If it's gone beyond the time, also they're looking at the date you were document qualified from the National Visa Center. So that is the date that you need to keep in mind when you're using this tool. And it is a first come, first serve basis. So yes, it is normal, but if your case is way beyond what that IV scheduling status tool says for your embassy or consulate, I would definitely, you can reach out to the National Visa Center about it.
All right. Nicola is asking, I want to know if the embassy location affects how fast my case moves.
Well, as I mentioned before, there's, if you're at a place like Ciudad Juarez, where the wait time is 1 year, yes, it can affect it. But you don't really have a lot of choice over where your case is going to be interviewed. So it's really kind of out of your control at this point. And the best way you can mitigate these delays is by making sure you have everything you need when your interview time comes, so that you don't experience further delays. Because if your case gets put on hold after the interview because you're missing something, it kind of just goes in another queue, and it could really delay your case a lot. So being prepared for your interview is really important to mitigating those delays.
All right. Shanice is asking, will my wife and I need to attend the interview?
So everyone who is even a baby has to attend the interview if they are a beneficiary in the petition. If you are the spouse petitioner in the United States, you don't have to attend the interview. In fact, some locations don't even allow anyone who is not being interviewed to enter the embassy or consulate. This is kind of a location specific thing, so you're totally fine to ask if that's okay. Usually most embassies have that information on their website. If your spouse does just want to travel there, though, for your interview, even if they're not allowed in, sometimes it can be helpful because if the consular officer does have relationship questions, sometimes you say, hey, my spouse is just, around the corner in our hotel room. Can I get them? And sometimes they'll say, yes, bring them. And they'll do the marital interview right there if they feel like it's necessary, because sometimes otherwise they might have to delay your case and do it. So, and sometimes just for the emotional support, it's good for them to be there, even if they're not actually allowed in.
Okay. All right. Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Johnson, for sharing your knowledge and practical guidance with us today.
It was my pleasure. Thank you.
You can always visit immigrationquestion.com to ask immigration-related questions, stay updated on policy updates, and register for upcoming live events. If you missed any part of today's important discussion with Attorney Johnson, the replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Friday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.